one and all. Am I audible and clear to you? Please do let me know. One second, ladies and gentlemen. Please do wait for some time. By that I can fix audio and video. There is some problem in live streaming. Hi guys, please do let me know my audio and video clarity. Okay. Okay. What do you think? One second, ladies and gentlemen. Let me check with another video streaming here. Hi, respectable ladies and gentlemen. Welcome to Unacademy and a warm welcome to my YouTube live session here. I believe slides are clear to you right now. So, ladies and gentlemen, this is a live session. There is some audio problem to couple of aspirants. It will get fixed as the time progress. And if you do have any doubt in between, please do let me know. So ladies and gentlemen, I will be quite louder now onwards because there has been some audio problem, if I'm not wrong. So let me raise my voice a bit. By that you can hear to me loud and clear. So here, ladies and gentlemen, so why don't we get started right now? Okay. So this is me, Rangu Satish, one of your favorite educator on the platform, that is Unacademy. and you can see me. I'm Rangu Satish. I'm a verified educator on the platform, and I have been teaching on the platform for the last 2 years, and I do have 7,100 followers, and a couple of aspirants have already said I'm a big fan of you, sir. So I do feel great honor to get associated with the serious aspirants like that. So raise it from OBS, Parvinder Singh. Okay, Parvinder Singh, please do let me know where can I raise it in OBS. I did it. Please do let me know. No. Now is my audio louder to you guys? Is my audio louder to you guys? Is my audio clear to you now, guys? Is my audio clear to you now, guys? So guys, I think I cannot rectify more than what we have right now. So let me get started because some of the aspirants have been waiting for it. So please do forgive me this time at least, and from tomorrow onwards I would be very clear to you, and I will get it fixed by the tech team of Unacademy. So this is me, Rangu Satish, one of your favorite educator on the platform. I have been teaching on the platform for the last 2 years. I'm a educator for Indian polity and law optional in Unacademy, and you can look at my followers, where I do have more than 7,000 followers, and where I have done more than 83 courses. So majority of the courses are on Indian polity and law optional. Please do go through all the polity courses like NCERT based polity questions and Lakshmikant's in 76 days course. These courses would really help you in getting through the prelims, which is scheduled on June 2nd, 2019. So ladies and gentlemen, another important point I would like to say is that we do have this plus subscription nowadays, where you will get 6 months, 1 year, and 1 month of subscription. Please do go for either 6 months or 1 year. By that you will have the perpetual continuity of the courses, and you will get benefited immensely rather than going to the Delhi to shell out the money over there. So ladies and gentlemen, here I believe some audio and video is clear to you. So my friend sitting next to me saying that there is indeed clear clarity of audio. So let me get continued with the lesson. So here okay, cool. Okay, so ladies and gentlemen, so here we do have a course that is 150 most important polity current affairs through MCQs with explanation for UPSC CSE, and we do have launched this course on 1st March, and it will be going to end on 11th March. Okay, so ladies and gentlemen, the first course which we had done was on 1st March 2019, where I had covered a couple of multiple choice questions of Indian polity current affairs, and we had also done couple of questions on March 3rd, which you can access through the links given below. And today we are going to discuss another couple of questions on polity current affairs in today's class. So ladies and gentlemen, please stay tuned. By that you will have the picture clarity of polity current affairs questions. So coming to the first question, the Sexual Harassment of Women at Workplace Act 2013 was legalized in the pursuance of the Supreme Court's Joseph Shine judgment, Vishaka judgment, Haji Ali case and Prakash Singh case. Here the answer is B, ladies and gentlemen, that is Vishaka judgment case. Okay, so here the Vishaka guidelines introduced by the Apex Court in 1997 were evolved into a parliamentary law called the Sexual Harassment of Women at Workplace Act of 2013. So ladies and gentlemen, here I would like to go beyond what is being mentioned in the question. So ladies and gentlemen, the sexual harassment of women at workplace had been an issue before 2013. Way back in the year 1997, Supreme Court of India recognized this problem among the women working in corporates and made certain guidelines called as Vishaka guidelines to protect the women from the sexual harassment of workplace. Okay, from the sexual harassment at workplace. So let me maximize the screen here. Okay, so later on the government of India had to give in to the demand of the public at large, and they made a formal law on it in 2013, and the law is called as Sexual Harassment of Women at Workplace Act of 2013. So moving on to another important question. Consider the following statements about Section 7 of the RBI Act 1935 that was recently in the news. It requires the central government to hold consultations with the governor prior to giving directions to the RBI to take certain action in public interest. A similar provisions has been built into the law that govern regulatory bodies in other sectors. Which of the following statement given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. Here the answer is C, ladies and gentlemen, that is both 1 and 2. So Section 7 of RBI Act had been in the news, hence this particular question has been asked. So let us look at the explanation of this question. Amid, that is in between, there has been tension between the government and Reserve Bank of India. The former has reportedly initiated steps towards invoking its powers under Section 7 of RBI Act of 1934. It is a provision under which the government can give directions to the RBI to take certain actions in the public interest. This provision has been built into the law governing not just the RBI but the regulatory bodies in other sector. Hence the answer is C, ladies and gentlemen, that is both 1 and 2 are absolutely correct in relation to the Section 7 of RBI Act, which is relating to the provision of public interest. Moving on to another important question, that is, consider the following statement with reference to the subordinate courts in India. Appointment, posting and promotion of district judges in a state are made by the governor of the state in consultation with the High Court. Appointment of persons other than district judge to the judicial service of a state are made by the governor of the state after consultation with the State Public Service Commission and High Court. Which of the following statement given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, option D, neither 1 nor 2. So अभी आपका आंसर दीजिए in the comment box में. So I'll wait for 15 seconds. students have written their answers here, and Parvinder Singh has got it right, and ICM Academy has also, a couple of others have got it right. So I really appreciate you have answered it right. So the answer is C, ladies and gentlemen, that is both 1 and 2 are correct. So with reference to statement 2, that is appointment of persons other than district judges to the judicial services of a state are made by the governor of the state after consultation with the State Public Service Commission and High Court. Hence the explanation here is that in practice the State Public Service Commission conducts a competitive examination for recruitment to the judicial services of the state. So ladies and gentlemen, the Modi government would like to introduce Indian judicial services. If at all it is introduced in India, there would be increase in the number of posts in civil services, which would be a good news to many aspirants. And second thing is that that would be under the control of the UPSC, that is Union Public Service Commission. Okay, so ladies and gentlemen, moving on to another important question. Before that, let me message to my tech team regarding the audio and video clarity. Okay. So guys, coming to this question, consider the following statement about the provisions in the Citizenship Amendment Bill 2016. The bill amends the Citizenship Act of 1955 to exclude some sections of the people from being threatened, from being treated as illegal migrants. Okay. 1 minute, ladies and gentlemen, please do wait. It dilutes the qualification for being able to apply for citizenship by naturalization for a certain section of the people. Which of the following statement given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. I will give you 15 seconds to attempt your answer. So ladies and gentlemen, here the answer is C. So ladies and gentlemen, as you all know, the original Constitution of India had not made any detailed provision regarding the citizenship. It had just outlined what is citizenship and what are the aspects of citizenship in the part 2 of the Indian Constitution from Article 5 to 11. However, it has given wide range of powers to the Parliament of India to do what is required to make the citizenship a very good laid out one in Parliament. So the Parliament has been given all the power to look after the provisions of citizenship. Hence, the Parliament of India has made the Citizenship Act of 1955 to detail out what exactly the citizenship is and who are eligible to citizenship and who are not eligible to citizenship, who can terminate the citizenship, and among the other things. So this particular question has been asked in relation to the illegal migrants. So illegal migration has been happening from Bangladesh, Myanmar, among the other regions. So let us look at the explanation here of definition of illegal migrants as well as the citizenship by naturalization. So the Citizenship Act of 1955 prohibits illegal migrants from acquiring Indian citizenship ship. Okay, so it defines an illegal migrant as a foreigner who enters India without a valid passport or travel document or stays beyond the permitted time. So ladies and gentlemen, there are two types of illegal migrants in India. The first being the one who enters into India through the porous borders. We do have porous borders with Nepal, we do have porous border with Bangladesh, we do have porous borders with other countries, which are located in the adjacent to northeastern region of India. So they do enter into India through that porous border. Take for example Rohingya migrants who had sneaked into India and settled in Jammu and Kashmir and some parts of the Hyderabad. So these are considered to be illegal migrants. And second type of illegal migrants are those who stay in India beyond the permitted time. So ladies and gentlemen, there are a couple of people who do come to India on a work visa which will expire after some time, or on a travel visa which would expire on some time. However, they would not go back to their country and they would stay beyond the date which is mentioned in the visa. So the amendment bill amends the act to provide that the following group of persons will not be treated as illegal migrants. The first being Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan. So ladies and gentlemen, you can clearly see that Muslims has been left out here to be the persons who can be concluded as legal migrants into India. So this has been done in under the Modi government. So who have been exempted from provision of the Passport Act 1920 and Foreigners Act 1946 by the central government. The 1920 Act mandates foreigners to carry passport, while the 1946 Act regulates the entry and departure of foreigners in India. Moving on to another important definition, that is on citizenship by naturalization, which says that the Act allows a person to apply for citizenship by naturalization if the person meets certain qualification. One of the qualifications is that the person must have resided in India or have been in the service of the central government for at least 11 years before applying for citizenship. So ladies and gentlemen, here it has been mentioned that who would like to be a citizenship by naturalization, he will have to stay in India for a couple of years. So you can go through the part 2 of the Indian Constitution, which clearly outlines how many years a person will have to stay in India to be called as a naturalized citizen. So please do mention in the comment box if you do know the tenure, that is to acquire the citizenship by naturalization. Or else he can work for the government of India for 11 years before applying for the citizenship by naturalization. So the bill creates an exception for Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan. With regard to this qualification, for this group of persons, the 11 years requirement will be reduced to the 6 years. So this is an exception to these communities from these countries, by that they can acquire the citizenship by naturalization despite of not residing in the country for 11 years. So it has been made to a 6-year one. So moving on to another important question, consider the following statement about ordinances. What exactly ordinance means, ladies and gentlemen? Ordinance means issuing an order by the President of India or the Governor of the state when two houses of the Parliament or state legislature is not in session. So ladies and gentlemen, you often see that we do have 3 sessions in Indian Parliament. First is the budget session, the second is monsoon session, and third is winter session. So in between these sessions there would be a gap of a month or 2. So during that time, if there is any unavoidable situation arises, take for example, there has been an urgent demand of the triple talaq. So there had been an ordinance in that regard, and the President of India had to issue that ordinance in order to meet the demand of the people at that time. So at that time there was not the Parliament was not in session, hence the President of India had to issue that ordinance. So ladies and gentlemen, ordinance is issued by the President of India under Article 123, whereas the Governor of the state can issue ordinance in relation to the state government under Article 213. So both the houses of parliament can pass resolution disapproving an ordinance. 6 weeks is the maximum life of an ordinance upon the reassembly of both houses of the parliament. Which of the following statement given above is correct? Option A 1 only, option B 2 only, option C both 1 and 2, option D neither 1 nor 2. Ladies and gentlemen, please do give me your answer in the comment box. I'll wait for another 15 seconds. So here the answer is C, that is both 1 and 2. That means both the houses of parliament can pass a resolution disapproving an ordinance. So ladies and gentlemen, once the house reassembles, then they would see whether an ordinance issued by the President of India is in accordance with the rules and regulations of the house or not. Another thing, they would see that would they garner the support of the parliamentarians to pass the bill or not. If the government cannot secure the support of the parliamentarians to pass the bill, then the ordinance will cease to exist. Another one is that the life term, the maximum life term of the ordinance is 6 months and 6 weeks. That means it will have to be either approved or disapproved within the 6 months of an reassembly of the House of Parliament. So moving on to the explanation of this particular question. Every ordinance issued by the President during the recess means which is not in session of the Parliament, must be laid before both the House of Parliament when it reassembles. If the ordinance is approved by both the houses, it becomes an act. If Parliament takes no action at all, the ordinance ceases to operate on the expiry of 6 weeks from the reassembly of the Parliament. Hence, it could be understood that the maximum life term of the ordinance is 6 months and 6 weeks. Another important point to be noted here is that the ordinance may also cease to operate even earlier than the prescribed 6 weeks if both the houses of Parliament pass resolution disapproving it. If the House of Parliament are summoned to reassemble on different dates, the period of 6 weeks is calculated from the later of those dates. This means that the maximum life of an ordinance can be 6 months and 6 weeks, what I had said already. So in case of non-approval by the Parliament, 6 months being the maximum gap between the two sessions of Parliament. So ladies and gentlemen, the rules of the House, the rules of the rules of the Lok Sabha and rules of the Rajya Sabha says that there should not be a gap of more than 6 months from one session to another session. However, the Indian Parliament has gone for 3 sessions. The first being the budget session, the second being the monsoon session, and third being the winter session. So there would not be gap of more than 6 months. Okay. So moving on, which of the following provisions in law or penal codes have been struck down in whole or in part by the Supreme Court? Section 69A of Information Technology Act. Okay. So ladies and gentlemen, please do give me the answer to this question. Section 497 of IPC, Section 153A of IPC, Section 303 of IPC, Section 295A of IPC. Select the correct answer using the code given below. Option A 1, 3 and 4, option B 2, 3 and 5, option C 2 and 4, and option D 1, 2, 3, 4 and 5. So ladies and gentlemen, please do let me know the answer to this particular question. I'm going to give you 15 seconds. So ladies and gentlemen, the answer to this question is C, that is 2 and 4 only. So let us look at the explanation. So section 153A 295A of IPC. What is IPC? Indian Penal Code of 1860, and 69A of 80 Act of valid and legal still. Section 497 and 303 of IPC have been struck down by the Supreme Court. So ladies and gentlemen, 69A of 80 Act has also been struck down by the Supreme Court, as it said that there has been a moral policing by the government authorities when it comes to information technology. Take for example, there was a girl in Maharashtra. She had put up a status in her Facebook profile saying that why should Bal Thackeray be given the state funeral. So here that had made a ruckus in the social media, and she had to be put behind the bars for the comment she had put in her Facebook status. So ladies and gentlemen, this case has made the Supreme Court of India to strike down 69A of IT Act. Okay, moving on. Consider the following statement: like the Rajya Sabha, the US Senate consists of representatives of each state who have staggered 6 years term. Like the Lok Sabha, the US House of Representatives consists of members elected directly by the people for a term of 5 years. Which of the following statement given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. Here the answer is A, ladies and gentlemen, that is 1 only. Okay, coming to the explanation. In United States Senate, all the states are represented equally. So ladies and gentlemen, in US Senate means Rajya Sabha. So in Rajya Sabha they do have the equal representation from all the states. Take the example of any state, they would have the equal representation. Take for example the 1 seat for each state. However, when it comes to India, we do have different representation. In Uttar Pradesh you do have majority number of Rajya Sabha seats, while in some parts of the northeastern state you do have the minimum number of Rajya Sabha seats. So there would be a discrimination of having the number of seats for the states in Rajya Sabha. So regardless of the size of population, each state has 2 senators, that is 2 senators from each state in USA who serve 6 years term, unlike the House of Representatives where all the members must stand for election every 2 years. Only 1/3 of the Senate seats are filled with each general election. So ladies and gentlemen, this particular question makes you understand the difference between the United States Upper House Senate and the India's Upper House Rajya Sabha. So ladies and gentlemen, moving on to another important question. Consider the following statement: the territorial extent of the state and union territories are mentioned in the first schedule of the Constitution. Altering the name of a state by Parliament requires a prior recommendation of the President. Which of the following statement given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. So ladies and gentlemen, please do let me know your answer. So here the answer is C, that is both 1 and 2. Couple of aspirants have got it right and couple of aspirants couldn't get it right. No problem at all, but attempting the question itself is a great thing to do. And the answer is C, that is both 1 and 2. So ladies and gentlemen, the territorial extent of the state and union territories are indeed mentioned in the first schedule of the Indian Constitution. So ladies and gentlemen, as of now we do have 12 schedules, 25 parts and more than 460 plus articles. So you do have to know what is being written in schedules and parts of the Indian Constitution. So you do have to learn certain schedules like fifth schedule, sixth schedule and 10th schedule. So 10th schedule speaks about anti-defection law. There had been many questions on schedules of the Indian Constitution, and you will have to answer these kind of simple questions or factual based questions in your prelims. By that you will have high probability of clearing the prelims. So coming to another important point here, altering the name of the state by parliament requires prior recommendation of the president. Yes, ladies and gentlemen, here under article 3 of the Indian Constitution, the parliament is eligible either to alter the boundaries or name of the state of the country, name of the states of the country. So here under article 3, with the simple majority, a parliament can pass the law to give the effect to the state. So ladies and gentlemen, there has been many alterations being done in relation to the boundaries of the state. Take for example, during 2000 and in 2014 we do have the creation of Telangana state by bifurcating Andhra Pradesh. So here is the explanation what I have already discussed upon. Moving on to another important question. Under Insolvency and Bankruptcy Code, the National Company Law Tribunal, that is NCLT, will adjudicate grievances related to insolvency, bankruptcy and liquidation of different entities. The NCLT will have jurisdiction over companies and partnership firms. Appeal against order of NCLT can be challenged before the Supreme Court. Select the correct answer using the code given below. Option A 1 only, option B 2 only, option C both 1 and 2, option D neither 1 nor 2. And please do take your 15 seconds of time and answer this particular question. Okay. So ladies and gentlemen, this is a very important question. You will have to get it right at any cost. Please Google it if you would like to. So ladies and gentlemen, coming to the answer, here the answer is D, that is neither 1 nor 2. So let us look at the code here, that is Insolvency and Bankruptcy Code of 2016. So the Bankruptcy and Insolvency Adjudicators Code of 2016 says that the code proposes 2 separate tribunals to adjudicate grievances related to insolvency, bankruptcy and liquidation of different entities under the law. So ladies and gentlemen, the 42nd Constitutional Amendment Act of 1976 had created tribunals under Article 323A and B in order to have certain subject experts as judges in tribunals to deal with certain matters which are of high subject matters like spectrum, like dealing with IT cases, among the other things. So the first thing here to be mentioned is that the National Company Law Tribunal will have jurisdiction over companies and limited liability partnership, and the Debt Recovery Tribunal will have jurisdiction over individual and partnership firms. Appeals against orders of these tribunals may be challenged before their respective appellate tribunals. It will be national, it will be NCLAT, and further before the Supreme Court. So moving on to another important question, that is, as per the Article 15 of the Constitution, the state is permitted to make any special provision for the advancement of any educationally backward classes of citizens. As per the Article 16 of the Constitution, the state can provide for reservation of appointment or post in favor of any backward class that is not adequately represented in the state services. Which of the following statement is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, option D, neither 1 nor 2. Please do take your 15 seconds of time to answer this question. So here the answer is B, ladies and gentlemen, that is 2 only. Okay, coming to the explanation. As per the Article 15 of the Constitution, the state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled caste and scheduled tribes. Okay, so hence the answer is B, that is 2 only. So ladies and gentlemen, Article 14 to 18 of the Indian Constitution speaks of right to equality. That's why there we do have Article 17 and 18. Article 17 also speaks about prohibition of untouchability, and Article 18 speaks of prohibition of titles. Hence Article 14 to 18 to be read in its completely, incomplete. Okay. So moving on to another important question. Consider the following statement with reference to the applicability of the emergency provisions of the Indian Constitution to the state of Jammu and Kashmir. So right after the Pulwama attack, you will have to read certain aspects relating to Jammu and Kashmir, like Article 35A and Article 370. So unlike in other states, a proclamation of emergency can be made in the state on the ground of internal disturbance. The president has no power to declare a financial emergency in relation to the state. Financial emergency is done under Article Under Article 360 of the Indian Constitution, and president rules can be imposed in the state on the ground of failure of the constitutional machinery under the provision of the state constitution and not the Indian Constitution. Which of the following statement given above is correct? Option A, 1 and 2, option B, 2 and 3, option C, 1 and 3, option D, 1, 2 and 3. So take your time to answer this question. So the answer is D, ladies and gentlemen, that is all of the above statements are absolutely correct. So ladies and gentlemen, we do have 3 types of emergencies in Indian Constitution. The first emergency type is national emergency under Article 352, and second type of emergency is state emergency or presidential rule under Article 356, and we do have financial emergency under Article 360. So ladies and gentlemen, when it comes to emergency, all the states will have the same procedure to be followed. However, there are certain exceptions being given to the Jammu and Kashmir when it comes to these kind of emergencies. So here these are the points which would enlighten you about certain exceptions given to the Jammu and Kashmir in relation to these emergencies. Okay. So ladies and gentlemen, moving on to another important question, perhaps the last question of this particular lesson. No, not last but one. So each House of Parliament can punish its members as well as outsiders for breach of its privileges by reprimand, admonition or imprisonment. The House of Parliament as well as state legislature have collective privileges. Which of the following statement above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, option D, neither 1 nor 2. Here the answer is C, ladies and gentlemen, that is both 1 and 2 are absolutely correct relating to the privileges. So ladies and gentlemen, privileges means certain special rights given. So here we do have 2 types of privileges. The first type is called individual privileges and second type is called collective privileges. So individual privileges are given to the members of parliament, while collective privileges are given to the members of parliament as a whole. So parliamentary privileges is a chapter which you have to read in detail to understand certain concepts hidden in it. So if you do have time, please do watch my course on Lakshmikant's polity in 76 days, where I have detailedly mentioned the details of parliamentary privileges. So these are absolutely free courses, ladies and gentlemen. You can go to Unacademy Learning app and you can type my name Rangu Satish, and where you will get Lakshmikant's Indian polity in 76 days, where you will get all the details of Indian polity and how you got to prepare and how you can master Indian polity to leave no stone unturned to get every question right in your prelims. So please do go through the please do go through that Lakshmikant's polity course. So ladies and gentlemen, coming to the last question of this particular lesson, though some members of the Constituent Assembly had advocated the system of PR, that is proportional representation, for the election of the members to the Lok Sabha, the Constitution has not adopted the system due to two reasons. Specifically, these two reasons are: it eliminates intimate contacts between voters and representatives, it does not give any scope for organizing by elections, it promotes minority thinking and group interest, it increases the significance of party system and decreases that of voter, it is highly expensive. Select the correct answer using the code given below. Option A 1, 3 and 4, option B 3 and 5, option C 1, 2, 3, 4 and 5, option D none of the above. Here the answer is D, ladies and gentlemen, that is none of the above. Coming to the explanation, following are the two reasons why the Constitution has not adopted the PR system for election of the members of the Lok Sabha. The first one is the difficulty of the voters to understand the system due to low literacy scale in the country. So ladies and gentlemen, we do follow proportional representation system in relation to the president election, vice president election and elections to the Rajya Sabha. However, when it comes to the elections to the Lok Sabha, we do follow the first to the past post system. Okay, so we do not follow the PR system in relation to the Lok Sabha election. The first reason is that the people have in India we do have a good amount of illiteracy rate, so people cannot understand what exactly PR system and what exactly single transferable vote system or secret ballot system. Hence the Constituent Assembly had to go to the first to the past post system when it comes to the elections to the Lok Sabha. Moving on to another explanation they had given for subscribing to the fast to the past for going to alternative system of election is that unsuitability to the parliamentary government due to the tendency of the system to multiply political parties, leading to instability in government. So ladies and gentlemen, in proportional representation you will have the bifurcation of the votes based on different caste, community, creed, color, religion, race. So ladies and gentlemen, then the members of the Constituent Assembly had feared that there would be division of the country into multiple ways, that is based on color, caste, region, race. Because India is a diverse country, if we go for proportional representation system, every person of their community would elect the person of that community rather than electing the person of the meritocracy. So it would lead to disintegration of the country, hence the members have gone for another alternative system of election process. So the other reason mentioned in the options are some of the general demerits of the PR system, which you can mention in your mains answer writing, if at all there has been any question in this regard. So ladies and gentlemen, I believe you must have liked this particular class here where we have discussed a great number of MCQs which have the high probability of getting featured in your prelims. So ladies and gentlemen, you can subscribe to Unacademy Plus courses, and please do give the referral code Rangu Satish. By that you can claim 10% of discount. And if you do have time, please go through Unacademy Learning app. That is a free app where you can access free videos. So please go through Unacademy Learning app and type Rangu Satish here in the search box. By that you will get 83 courses of mine which you can access for free, where I had uploaded many lessons regarding to Indian polity. Do not forget to go for Lakshmikant's Indian polity in 76 days course, which will cover the entire Indian polity in detail. So ladies and gentlemen, thank you so much for your continuous support and love. It's been a great honor indeed, and thanks for all the support in the comment box. So ladies and gentlemen, thank you so much, and I wish you all the best for your future endeavors, and please do join me day after tomorrow for another class on Indian polity MCQs based on current affairs. So day after tomorrow also I would be going to discuss another couple of MCQs. By that we will complete 150 questions in detail. So ladies and gentlemen, thank you so much for being with me in this particular lesson. It's been a great honor indeed. Thank you so much.